Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today I'm bringing you an update on the Kraken lawsuit. I've done two previous videos on the Kraken lawsuit down in Georgia. In this one, we're going to be talking briefly about Georgia and briefly about Michigan. Both of these cases had big news today in that both of them were dismissed at the district court level and for basically the same reason. And it's the same reason we saw up in Pennsylvania with a non-Kraken lawsuit. And this reason is on appeal to the Supreme Court up in Pennsylvania and will be on appeal to the Supreme Court likely here in Georgia and Michigan, although they'll probably have to go through the hurdle of appealing for emergency orders from the appeals courts in those districts and then go up to the Supreme Court of the United States. But the long and short of this is these lawsuits were dismissed because judges in both states have determined that they waited too long, and the doctrines of latches and mootness, along with some other ones in Michigan, it's lack of standing and 11th Amendment immunity. That is the state's immunity from a lawsuit. Those doctrines all apply. And for those reasons, the courts do not have the power to grant what the plaintiffs are asking for, which is the invalidation of hundreds of thousands to millions of votes. And let me be very clear, for all of the legal doctrines in the world, all of those legal doctrines are a way for the judges to do what I just said, and that is to avoid impacting these hundreds of thousands to millions of votes. I've maintained for a long time that it's very unlikely that a judge will do this. It's just a big thing to ask a judge to do. Do I think judges can do this? Yes. And I think they're using or utilizing these legal doctrines as cover for the realization that they would be, in their mind, invalidating the votes of millions of people. Now, there's a very good argument that millions of people's votes have been invalidated by fraud, and I'm not denying that argument in any way. I'm just relaying what judge after judge after judge has said. Now, there is a chance that the Supreme Court justices of the United States, being thoroughly detached from individual states and thus the voters in individual states, may have a different opinion on this. I don't think it's likely that they will, but it certainly is possible. And if there is a court positioned to take the position, if they're positioned to take the position that they can invalidate a specific number of votes or decertify, or however you want to word removing votes because those votes are intermingled with fraudulent votes, it is the Supreme Court. That is the one who can do it, and they are both politically insulated and spatially insulated from the states where this stuff is occurring, allegedly. So that is the big issue here. The judges in the lower courts are not going to overturn elections, and so they are dismissing these cases. And they're laying out legal doctrines as to why they're doing it. And what I want to do with you now is I want to first listen to Judge Bratton down in Georgia, and then we'll read the words of the Michigan judge as well. And you'll notice some similarities in what they say. And I'll give you my thoughts on that. And then we'll talk about the next steps and what's going on here. So here's Judge Bratton. Oh, very briefly, let me just remind you, Georgia is the last video that I did. And that was where they had gotten permission to halt the software updates on 3 counties worth of Dominion servers, and and they had a hearing coming on December 4th to do a forensic audit of those, to ask for a forensic audit of those machines. Then they appealed that order and went to the 11th Circuit Court of Appeals. That appeal was denied, as not being ready to be appealed because there wasn't an appealable order, and then it was kicked back to the district court. This is the hearing. The reschedule of that December 4th hearing was today on December 7th, and this is the closing minute 45 seconds from that hearing. Okay, sorry, I should have mentioned that. Here we go.
Additionally, I find that the plaintiffs waited too late to file this suit. Their primary complaint involves the Dominion ballot marking devices. They say that those machines are susceptible to fraud. There's no reason they could not have followed the Administrative Procedure Act and objected to the rulemaking authority that had been exercised by the Secretary of State. This suit could have been filed months ago at the time the machines were adopted. Instead, the plaintiffs waited until over 3 weeks after the election to file the suit. There's no question in my mind that if I were to deny the motion to dismiss, the matter would be brought before the 11th Circuit, and the 11th Circuit would reverse me. The relief that the plaintiffs seek, this court cannot grant. They ask the court to order the Secretary of State to decertify the election results, as if such a mechanism even exists, and I find that it does not. The 11th Circuit said as much in the Wood case on Saturday. Finally, in their complaint, the plaintiffs essentially asked the court for perhaps the most extraordinary relief ever sought in any federal court in connection with an election. They want this court to substitute its judgment for that of 2.5 million Georgia voters who voted for Joe Biden, and this I am unwilling to do. The motion for the temporary restraining order that was entered on November 29 is dissolved. The motions to dismiss are granted, and we are adjourned.
And thus we come to the crux of the issue, right? Judges are unwilling to invalidate, decertify, remove, otherwise ignore votes, especially on such a large scale. So we'll read the words of the Michigan District Court judge, which are going to sound maybe similar. For these reasons, the court finds that plaintiffs are far from likely to succeed in the matter. In fact, this lawsuit seems to be less about achieving the relief plaintiffs seek, as much of that relief is beyond the power of this court, and more about the impact of their allegations on people's faith in the democratic process and their trust in our government. Plaintiffs ask this court to ignore the orderly statutory scheme established to challenge elections and to ignore the will of millions of voters. This the court cannot and will not do. The people have spoken. The court therefore denies plaintiffs' emergency motion for declaratory emergency and permanent injunctive relief. So, same thing in this case. They are unwilling to overturn, quote, the will of the people. Now, a couple thoughts. Again, I think I said earlier that does ignore the fact that the will of the people is potentially being overturned by fraudulent action. That would be, if there is the fraud that they claim there is, then the will of the people is being overturned in a different way, but the court is unwilling to do that. So that is, at least at this lower court level. So it is possible that the Supreme Court will think differently, but we will have to see about that. There are a couple of very important dates coming up. There's the safe harbor deadline, which is tomorrow, December 8th, and there is another deadline, and that is the electors actually casting their vote deadline, which is December 14th or 15th, one of those 2 days. And many election law specialists suggest that those 2 days are extremely important. Let me briefly address a counter argument that those days are not set down in the Constitution, so therefore they don't matter. While those two specific dates and the schemes to determine those dates each year are correctly not in the Constitution, the authority to set those dates is firmly in the Constitution, and it is what is called a plenary authority of the federal legislature. Okay, they have the authority in both Article 1 and in Article 2 to go ahead and set the dates and times for choosing electors and for the electors to cast their votes. That is within their authority, and that authority is not really questionable under the Constitution. Now, can a judge determine that those dates don't matter? In theory, yes. I think it's very unlikely that a judge or the Supreme Court will determine that the plenary authority of Congress to set dates should be overridden by the Justice Department or the judicial branch. They tend to not extend into the plenary authority of either branch of government. That would be like the judicial branch saying the president can't veto or pardon. It would be similar to saying that that Congress cannot make laws, for example, or levy taxes. Those things are enshrined in the Constitution. They are plenary powers, and it would be a very interesting legal argument that would overturn the idea, or that would introduce the idea to the judges that they could ignore that power of Congress. So I think that's a very unlikely thing. I know I've seen it in comments on my videos, and I want to just express that while theoretically a lot is possible, the idea that that will happen should be a pretty low idea, just due to the nature of what authority is actually granted to Congress under the Constitution and not granted to any other branch of government. So that's that. So the next steps in this have to happen very quickly by most accounts, and that is we have to go to the appeals court in each of these states and then up to the Supreme Court. I do believe they'll ask for emergency relief and emergency accelerated schedules, and maybe they will get them. And the appellate courts in both of these circuits are very likely to affirm the lower branches or the lower courts' decisions and say that these are time barred. I want to spend just another minute or two talking about my disagreement with how these cases are decided. Now, I know that I've said for a long time, I don't believe that judges are going to do this, but how they're deciding to do this is this doctrine called laches, or this doctrine of mootness. Mootness is at play up in Michigan. They say that these issues are moot because the relief requested has already occurred and you can't unwind the clock, so to speak. And we heard the same thing from Bratton down in Georgia, right? Can't undo the certification. They say the same thing in Michigan. Now, I don't think that that's necessarily true, that they can't undo the certification. I don't know what judicial mechanism there would be for doing that, other than they could just issue an order to undo the certification. But then at the same time, the legislative and executive branches of those states could ignore the order. So who knows there? But mootness is one of them. And that one is a little bit stronger. I'm not sure I fully agree. I think the courts may have some remedies, and not all of the elements of these cases are moot, even when some of them are. For example, certification may be moot, but there may be further steps to the certification that they could prevent from occurring, or they could, potentially try to issue some sort of writ to the to demand that the states change their course of action. I don't know. Again, there's not precedent for undoing the certification process, but just because there's not a precedential action for it or mechanism for it doesn't mean that one can't be created and implemented. The one that is more of a problem for me is laches, and that is this idea that the case isn't actually moot. Laches is not a mootness issue. Laches is what's called a balance of equities, and it looks at the two parties, and it says that party A, the plaintiff, may have a claim, but they waited too long, and it would be extremely harmful for party B to undo what happened, or to grant the relief that party A is asking. Ignoring the fact that ruling against any party can be extremely harmful in any sort of judgment, but they determined that party A waited too long, and therefore the harm to party B is too great to justify. And I don't really agree with using the laches doctrine in these cases, and I think it's disingenuous of the courts to say that it actually applies. You heard Justice Bratton saying down in Georgia that, well, this case could have been brought when they adopted the Dominion voting systems. Look, just because they are Dominion voting systems doesn't mean that fraud was definitely going to occur. And it doesn't mean that fraud, heck, it doesn't mean that fraud did or didn't occur or would or wouldn't have occurred under another system. The fact that the Dominion voting machines have these alleged mechanisms to implement fraud, and then they believe due to their analysis that fraud has occurred, is why they're bringing the claim. Do I know anything about it? No, I don't know if there's been fraud or not. I'm not... that's not my purview. It's not my area of expertise or anything like that. So whether or not there was fraud is up to them to prove and up to the other side to disprove, in my opinion. The laches doctrine says, well, they should have known all of this was going to occur and they should have sued beforehand. But that's not really how that works, because if Dominion voting systems had been used and no fraud would have been implemented in the systems, again, it's just a computer system. While they have the possibility to put fraud in, there's no reason that it necessarily must occur. And in fact, it may be the case that in many places that didn't use Dominion voting systems, there was no fraudulent issue at all. If they targeted, for example, swing states, where they thought they could make the most impact, then the fraud could be limited to not just Dominion voting systems, but these specific Dominion voting machines. This is all theoretical, of course. I have no idea. But I'm just pointing out that they waited for the injury to actually occur. They gathered evidence and information and brought it before the court in a very crunched time window. And that's the nature of how election lawsuits work. A lot of them work in this very crunched window between the time the votes are taken and the time the results are implemented. And so I don't agree that laches is the proper remedy, because just because they could have brought a case challenging Dominion voting systems, they would have been challenging the speculation that these Dominion voting systems would be implemented with specific code that would do it this way. And until that happens, there's no way on earth you can articulate that that will actually occur. So, objecting to the implementation of Dominion voting systems months ago when they were adopted rings a little hollow to me. But that's how it is. That's what the lower court judges have decided. We'll see what arguments they bring up the chain. Sidney Powell has been on the news, I think on Newsmax, stating that she expects to potentially see 3 different state suits brought before the Supreme Court within the week, which is possible if the Supreme Court is willing to grant cert and review these cases. Whether they will or not remains to be seen. There's a lot of reasons they may not, and a lot of reasons that they might. And none of those reasons are really indicative of how they will rule on the cases ultimately if they do take them. So there are reasons to take the cases that are not favorable to Trump, just as there are reasons to take the cases that would be favorable to Trump. So we'll see if they take them or not. If you want to follow along, like, share, subscribe, all that stuff, drop me a comment. Tell me what you think. Tell me I'm a horrible traitor to the Union or an upstanding and stalwart patriot. I love it all. Let me know how it is. Also, like, dislike if you hate it. That'd be great too. Thanks a bunch, guys. Hope you have a good night. Peace. Peace.